gun rights lawyer Matt Larosiere on the implications of the first post-Bruen ruling against the federal machine gun ban. That and more on this episode of the Weekly Reload Podcast. No, the devil's got no hold on me. All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also a CNN member, CNN contributor, and the founder of the Reload.com. I've been doing this intro like I had it memorized. It's down very smooth. I've done like 200 episodes of the show now, and tripped up on that version. But you can head over, of course, to thereload.com if you want to keep up to date with what's going on with guns in America. You can also buy a membership if you want to get extra insight into how things are going with firearms in America. You get access to exclusive pieces you won't find anywhere else, including all of our analysis pieces. This week, we are talking about the first case where a federal judge, I can't even talk this episode.
Federal drugs.
Federal Matt Drudge. A federal judge has tossed out machine gun possession charges for the first time since the Bruen standard was handed down in 2022. There was a Second Amendment challenge to a recent defendant's charges over possession of some pretty interesting fully automatic weapons. We'll get to that. But and to discuss this, you've heard him now a couple of times, but we have somebody who handles National Firearms Act cases. The National Firearms Act, for those who don't know, is what regulates possession of fully automatic weapons in the United States. And since 1986 is also the law that has banned new sales of fully automatic weapons to civilians. And that is a big part of this ruling. But I wanted to bring in a lawyer and somebody who actually interacts with these laws in court in real life to discuss this. And that's why we have Matt Larosiere. I'm never going to get your name right.
You got it right every time you were practicing it before you started recording. Oh my gosh.
Larosiere.
Conventional at that point.
You say it. So
Larosiere. It's fine.
There we go.
The French language deserves no respect, so just don't worry about it.
I can't. This has been anyone who's listened to the show long enough knows that I'm terrible at pronouncing names. At least the first couple of times somebody comes on, and so I apologize. But welcome back to the show. We had you on back in April now, I guess. And so you're coming back on. You host obviously in addition to your legal work in Florida, you also host a show called Fudbusters on YouTube. So that's sort of a legal analysis show, a bit of a different, I think, tone and tenor than perhaps our show, but get into a lot of the weeds on this exact kind of stuff. So tell people a little bit more about yourself and your show.
Yeah. Well, thanks for having me on again. Stephen, I've known Stephen for a long time, and it's funny because on my show, it seems like half the time we're talking about your articles, but the distinction is our tone is a little more irreverent and a
little bit, yeah,
decidedly less. You're sober, serious firearms reporting, and I think we're whatever the opposite of that is.
Right.
But I love the Reload because the greatest compliment somebody's ever given me on my content is N Block Press said that it presupposes a level of knowledge of firearms law and policy that most don't. And I think I'd give the same compliment to your content. Like you don't avoid getting into the weeds and discussing the merits of individual policies and legal contentions. And so that's why I'm always excited to work with you. But yeah, I've got, of course, I've got I hate to say broad just because of my, you end up making friends in this field that know more than you ever will. Right. But I've worked in the industry. I currently advise several major manufacturers and importers. And I do representation usually on a pro bono basis of people who are faced with novel and aggressive interpretations of the National Firearms Act. And so it's something that I'm frequently asked to opine on and to write on. And this is certainly an interesting matter. And it's the most interesting thing about it is how uninteresting everything before the ruling was.
Yeah, so this is a case called U.S. v. Morgan, right? We just had an analysis piece, one of those pieces only members have access to over at the Reload, where Jake Fogelman, my contributing writer at the Reload, went through and looked at this case and looked at this is because, like I mentioned at the beginning, it's the first time, as far as I'm aware, and as I believe as far as you're aware, that we've seen a machine gun possession charge tossed under the Bruen standard. Now, this is
under Bruen specifically. Yes,
they get tossed
fairly routinely, but this is the first time under Bruen.
Yes, so then that's what makes it significant, because this is a Second Amendment challenge.
Yes,
it's not just challenging some of the circumstances of the arrest or something like that, right. Which are obviously more common things to see in court proceedings. Second Amendment challenge to the underlying law again, this is an as applied challenge, right? So that means it's not, they didn't strike down the provision, for everyone. It's still in force. It's still in effect. Now it may have.
Well, so this one's interesting, right? Because there's the distinction between as applied and facial challenges, and they brought both here. And if this ruling is allowed to stay, and it has precedential impact in the 10th Circuit, which, if it is upheld on appeal, it would.
Right. You know what? I was confusing actually this with another case where it was the oh gosh, we talked about it in the news update. Yeah, I filmed it earlier. So that was the as applied challenge succeed. This is the marijuana user case,
right?
Out of the Fifth Circuit, where the as applied challenge was sustained, but the facial challenge wasn't. So
this winds up being
explain to us what happened in U.S. Morgan before we go further.
So Morgan is interesting because they brought a facial challenge, and then they also brought, by any other name, an as applied challenge. And so the court disposes of the facial challenge because after, really interestingly enough, Rahimi showed the court really nailing down that they don't like facial challenges, and that you have to basically prove that there is, and this goes back quite a couple decades, right? But in the Second Amendment context, you'd have to prove that there is no constitutionally acceptable application of the law. And the judge here in the Morgan case kind of hand waves away the facial challenge by using an analogy that the defendant made, saying the machine gun definition is so broad, it covers aircraft mounted cannons to potentially lasers. I don't know if I agree with that interpretation, but the court then used the linchpin of, well, aircraft mounted cannons aren't bearable arms, so it doesn't,
because you can't carry them around literally.
Yeah,
that's sort of the distinction the court makes in that section, right?
Yeah, and I'm not sure about all of that, but it's it at least gets us past talking about the facial and to talking about the as applied. And so the question here is mere possession, right? So the funny thing is, though, the as applied challenge is so close to facial that it's hard to really distinguish them.
And I would say that's kind of true for even the marijuana case too. Like it is. Anyone who's a marijuana user, at least in the Fifth Circuit at the moment, you're probably not going to get charged for owning guns.
I think it's a distinction without a difference. I think it's a purely technical thing. Right.
Of course, that Fifth Circuit case we've had 2 panel level decisions in the Fifth Circuit on that. This is a district court case. Yeah. It's a little bit different, right?
Yeah. So it has no precedential authority on the courts of appeal. It would have precedential authority in this particular court, but this doesn't mean clickbait thumbnail Supreme Court ablaze. The NFA is over.
I'm sure we'll see plenty of that on YouTube, like we obviously try to be a bit more, as you mentioned earlier, sober and serious here on our analysis. And so the practical implications are not that the NFA is now, unenforceable, but they're not nothing, right? Can you get into what they are?
So what's interesting here is that the motion to dismiss was fairly straightforward, and really, it was well done. And it follows the same lines of the ones that came before it, the ones that came after Bruen, which is, hey, 922.0, which is the actual section he was charged under, prohibits the simple possession, not connected with any particularly dangerous type of firearm, not connected with any type of activity. So basically 922.0 says no matter what, if you buy a machine gun that was not possessed by a individual before 1986 and you put it down in your safe for 20 years, you're just as guilty of a violation as somebody who buys it to then go and do terrible things, right?
Some other crime.
Yeah, or use it as a weapon, right? So the actual use of it as a weapon, which is relevant in other contexts in this area, is completely irrelevant in the machine gun context. And in fact, the machine gun definitions is one of the only ones that does not require the item be a weapon. But it could be, for example, the switch itself, the Glock switch, is not on its own a weapon. It's a part or combination of parts for another weapon. Right. So what this case is about, I guess kind of back up there because we didn't really talk about the circumstances. Mr. Tamari Morgan had in his possession, allegedly, two very interesting machine guns. So
interesting, yes.
Yeah, an Anderson Manufacturing AM-15, so kind of like your Wonder Bread AR-15, converted to full auto in 300 blackout. And then he had a Glock switch, which everyone's heard about Glock switches. These go on the back of a Glock frame to make them fire automatically. And this was affixed to a Glock Model 33 in 357 SIG. And so for those of you who don't know, that's like the smallest double stack Glock you can have. So it's like a Glock 26, but in 357 SIG, which is very stout.
Gotta be the weirdest full auto gun I've ever heard of.
So I think you'd wind up having like 6 or 7 rounds in the standard magazine for that, and then it'd be full auto. So it just truly bizarre.
Yes, what he actually possessed was accused of possessing is a very strange combination of weapons. But
it's definitely a min-max loadout.
Yeah, right. 300 blackout AR in full auto. They don't detail this. I would be interested in how he got that AR to full auto,
right?
Whether it's a drop-in auto sear or something, I don't know, but they don't talk about it. And then, presumably a Glock switched 33,
right?
Just a weird combination, but it is relevant to the point you made earlier about bearableness,
bearability,
whatever. Yeah.
So basically, this is actually public defenders, right? I've quipped many times that many of the best developments in firearms come from the public defender's office, right? Because they have no choice but to engage with this type of stuff and to engage to the best extent they possibly can.
And it's a relatively easy defense, or at least a relatively cost, effective one, because Bruen puts the burden not on the defense, but on the government, right? It's
a burden shifting defense, right? And so it's kind of a no-brainer thing to do. And so the attorneys are like, hey, the framework says if it's bearable arms, it has to be justified. And so they haven't done that. In every other case this has happened, the prosecution, the defense cites Bruen, says there is no historical analog that can be identified, and so we must win. And then the prosecution will quite lazily and oftentimes word for word copying previously used motions by the government, basically just say, no, but Heller.
Yeah, I've noticed that in a lot of these cases as well.
Yeah, with no mention
over and over again.
Particular historical analogs, just, but Bruen didn't overturn Heller. Well, Heller didn't actually say anything about the NFA. I mean, there was dicta where in the discussion, they were saying, well, this would be, shocking or whatever, but the actual line that they talk about, right, that they cite that says M6 restrictions on M16 rifles and the like, the full context of that dicta was historical analogs for restrictions on dangerous and unusual weapons, M16 rifles and the like, should they exist, will come to light in future litigation.
Right.
And so the government's kind of trying to flip the burden here by saying, but Heller, and it's like, yeah, no, but Heller said someday you're going to have to prove this. And so now it's your turn to prove it. And they've never done it. And the reason they've never done it is because there actually aren't any historical analogs. The closest thing they have is the Statute of Northampton, and the 2 or 3 times that was invoked in the early American history. But as the judge in the Morgan case points out, that's not analogous at all. Again, that's the big law that the government has relied upon here. And one, it's from way too early to be relevant to the passage of the Constitution. It's like an old English concept. And 2, it concerns conduct. It concerns actual bad intention actions. So it's the carrying of dangerous, unusual weapons in such a way or such a manner that would, or as to, instill terror in the people.
Right. Going on to the terror of the people, I believe, is the common phrase that survives through that history, even into early American law that existed at the founding era, which is, what they're citing this. It goes back much longer than that, but it did continue into the American founding era. But it was, like you said, it was about going armed to the terror of the people. And it was sort of about the context, as far as I understand it, is, and as far as I've seen it written out by the Supreme Court and other courts, was, sort of a highwayman situation where people would roaming bands of robbers, basically going around intimidating people with their weapons into, robbing them essentially, or making them do what they want. And so it's,
so the history of it is actually kind of a little more subversive than that, right? Because it first comes around because the king is concerned he's going to be overthrown, right?
Sure.
And so that's a little bit different than, general highwayman misbehavior.
Yeah, but that's kind of what it warps into later on.
It does.
As I understand it.
And that's the beauty of the English common law, is these these mixes of decrees of the king and common practices merge into something. And so the kind of English common law result here was exactly as you said, a phrase and going armed and stuff like that. That's all stuff we can get historical support for, but it's not constitutionally significant for a Bruen analysis, because it's very clear we need a historically analogous law. And Rahimi showed us that they're not concerned so much about how the law was enacted, right? Because that would kind of be the reverse problem of, it only protects muskets, right? That would kind of be, it only protects muskets, but in our favor. So Rahimi said it doesn't matter how they did it. What really matters is that the why is analogous. And so the why of the going armed and the Statute of Northampton is, we do not want people banding and like swinging around flaming dead cats and things, right? To rob people and otherwise steal power or like discourage.
Yeah, there's an intent to intimidate or to to scare people with the weapons that you have. That's sort of the core of what they're trying to get at. And so that would be the why aspect, right?
Then what's the why of what we're talking about here? And remember, we're not talking about the NFA. We're talking about the Firearm Owners Protection Act in 1986. Right. The NFA is not relevant to a 922-0 prohibition. So whatever the thing about, mobsters and this and that, it's not really relevant here. The question is, how come when every other NFA firearm you can own, as long as you're willing to pay the tax, right?
The registration.
The tax is only $5, right? And you're otherwise not prohibited. But in this instance, for this type of item only, you can only have it if someone else had it pre-86, to which the practical effect is you can only have it if you have enough money. The why there is very hard to track.
Right. Well, and the money thing is just because there's a limited supply of how many of these exist. Although I guess this was right. So just to I guess finish off this aspect of what we're talking about here. In your view, and I think this is a good description of what the judge holds. Basically, the historical analogs they cited really aren't very similar at all to a total ban on possession of of machine guns for everyone. Because that's what the law effectively does. At least new production machine guns. Let's say that post 86 production machine guns. You can't buy them as a civilian without. Now, obviously, there are a certain number of exceptions to this that have to do with certain kinds of FFL licenses.
Well, and those are all for prospective government sale.
Right. So it's a very limited. There's very limited number of ways that you could, as a civilian, own these firearms.
Right.
But for the general public, for the general population, it's a possession ban on post 86 fully automatic weapons.
Well, note that the judge does note that there are many hundreds of thousands of registered machine guns that were
right. And I do want to get to that in a moment, but because that gets into the sort of common use.
Well, I think here's the way to put a pin on it, right? You need a historical analog, right? Mm-hmm. We have what the government's proposed as analogs, and we have their why.
Right.
But we're not even sure of the why of FOPA. And frankly, that's because it was added rapidly. The why of FOPA, the why of 922.0 is to prevent Reagan from signing FOPA. That's why. And they were shocked that it passed anyway. So there's not a developed record as to why they cut off post 86 machine gun possession. So it's hard to have an analogous why, frankly.
Right. But needless to say, the ones they put up aren't really
supportable at all.
Even if you could say the whys were similar, the how is certainly very different, because Northampton, that's about restricting carry of weapons.
Right.
These going armed laws weren't about possession necessarily. They were about the act of going out armed and scaring people.
Yeah.
And this is just a straight up possession ban, which there's really not much of a historical analogy for that at all, especially like just a general ban. And this goes back to Heller.
Right.
In a lot of ways. And the handgun ban that was at issue in that case. But that's, so basically there's the judge looked at the Bruen test, what the government put up, and said, this isn't an acceptable analogy. This doesn't fit.
Right.
And then he moved on from there, and got into this idea of dangerous and unusual weapons from Heller and common use. And that's where he cited I guess there's about 700,000 fully automatic weapons on the NFA registry today, right?
Yeah.
And that's what he points to as evidence of common use for these sorts of firearms, right?
Well, so I don't necessarily think that he's saying common use, because remember, common use isn't an independent test. Mm-hmm. And a lot of people misunderstand that. A lot of people think that you need to have common lawful use in order for something to be protected at all. I don't think that's true. That may have been what Heller suggested, but Bruen clarified otherwise. Bruen clarified, is it a bearable arm? If yes, step 2, what's the analog?
Interesting. So why do you think he brings it up then in this?
Because the government asserts, as if it was a talisman, dangerous and unusual. They just keep saying, but it's dangerous and unusual, but it's dangerous and unusual. So it's not necessarily that he's suggesting that these are in common use for X purpose, but how is it dangerous and unusual if you, Mr. or Madam Government, have approved the private possession of this many of them? Then that's not dangerous and unusual at all.
I mean, is that like a huge difference is that kind of a semantic thing, or do you view it as
I think it's important because the way many people in our space perceive common use is like this past the post thing where you have to get past it to get any constitutional protection. And I don't think that's true. So I think suggesting that common lawful use is a predicate to Second Amendment protection is a mistake. And I don't think that that's in here. I think it's a counter argument to the suggestion that it is somehow outside the scope of Second Amendment because it's dangerous and unusual.
Okay. Interesting.
Even though dangerous and unusual, dangerous and unusual is not and has not been held to be something that on its own allows you to escape constitutional protection.
Mm-hmm.
The court has simply noted basically in refusing to overturn Miller,
Right.
it just noted that, oh no, this actually would be in line with a historical tradition of regulating this, but that's not before us today, and we'll deal with that later, right?
Mm-hmm.
So,
and speaking of Miller, where this really all, obviously people mainly think of Heller, but Heller is based on Miller, or at least is sort of working around Miller, or going off of Miller.
Yeah.
And
in the Miller,
how do you take, because Miller is about the NFA, right? And it's about a specific restriction on short barrel shotguns within the NFA. So how, and does come up in this ruling. Can you take us through that section? Because Miller, for anyone who doesn't remember, was really actually one of the first times, maybe the first time, that the Supreme Court dealt with Second Amendment claims at all. And it was a challenge to the National Firearms Act, where it was a very strange case, right?
I just forgotten what he said about Miller, and
so in the case, someone is charged with very strange procedurally, because I think the defendants weren't even there. It's very if you look into Miller, there's a lot of strange stuff going on. I mean, it's not a very long decision; like the opinion's pretty short, but effectively it upholds the ban on, or the regulations that the NFA puts on short-barreled shotguns,
specifically traveling interstate with a short-barreled shotgun,
right? Because they go back to the idea that the only weapons protected by the Second Amendment were the ones useful in militia service, and the guns that would be useful, that people would show up to if they were to muster for militia service, are ones in common use. And short barrel shotguns aren't in common use; they aren't useful in militia service, so they're not.
So it's actually more interesting than that, because in Miller, they were very specifically trying to uphold the short barrel shotgun regulation. Nothing else was before the court in Miller, and so the Miller discussion really drives into, no, these have to be weapons that are useful in militia service. And what sort of weapons are useful in militia service? And it actually says military weapons.
Right.
And
which I question the outcome there too, because shotguns are definitely useful in military service. At this time, we still use them together.
Well, and remember, at this time, it was before information spread as freely as it does now, and the court just presumed that shotguns were not useful in military service,
which is kind of ironic, because after World War I, that's when this happened, shortly after World War I, right, in the interwar period. And in World War I, the Germans filed a complaint that our use of trench guns, as they were called, which are just shotguns, during that war was a violation of the Geneva Conventions, right? That it was a war crime. Now, it didn't go anywhere, but it was a real thing that happened. And so it showed you that we were certainly using shotguns to apparently pretty good military effect during that war,
or at least
before Miller happened,
or at least to some military utility. And so the Miller court kind of just ignores this, probably because they didn't know. Frankly, that the research was harder back then, and information like that was harder to get through. So probably just didn't know. So you can
also sort of ironic, right? It is, because how has the debate shifted since Miller? Right, because Miller is all about how the Second Amendment only protects guns that are useful in military service.
Yeah, and now people are like, "No, it's not a military gun; it's my modern sport gun." It's like, okay.
Well, today the whole debate is the exact opposite, right? Which is that this military weapons, weapons of war, right? You hear it all the time. These Second Amendment doesn't protect weapons of war.
It kind of just underlies how hilariously unprincipled the whole thing always is. But anyway, so. And the judge here kind of observes that, and it's like, well, there's no such showing here, right? In fact, the military uses machine guns constantly, so we don't have to engage with Miller. It doesn't preclude the analysis,
right?
And so it kind of just he kind of does hand wave away Miller like that, and I think it's a correct hand wave. But yeah, that was the getting around. Miller, as it were.
Right. And actually, one more question on the 700,000 count, right? This NFA registry.
I'm not sure about that.
One of the things that you notice about it is that it goes up quite a bit after 1986, and the reason is it seems to be that what the Hughes Amendment doesn't ban is law enforcement use of fully automatic weapons for some reason, but it does still require them to be registered.
Right.
So I think most of the guns in there now are probably owned by law enforcement rather than your civilian. I mean, I think there still would be a couple 100,000 that are civilian owned. Like that population of what civilians can own hasn't
estimated
changed
to be about
much.
250,000. Yeah. So it's
still a lot of guns, but it's not. I don't think that it's the 700,000 that. Although I don't know if that matters much if you're talking about whether they're too dangerous, right? Because
here's the other question: is a law enforcement is not military.
Right.
That's certainly a civilian job.
Not supposed to be, at least.
So, it may have taken on a more military character.
But more militarized.
Yeah. Well, legally speaking, law enforcement officers are civilians. And so if they're using machine guns, they're lawfully using firearms.
Right. So I guess it perhaps still applies. It's just, I just, had that thought when I was reading his cite of that, because I think people don't really understand what that number represents, and I think the vast majority of it now is likely law enforcement weapons rather than civilian owned, because the civilian number hasn't really changed since 1986.
No, in fact, it's gone down because the ATF does a great job at tricking widows into giving their guns up.
Yeah, I mean, you've had like the machine gun attractions that exist out there. They mainly are able to own them through that exception we talked about earlier of like FFLs with certain licenses can have fully automatic weapons for demonstrative purposes for law enforcement agencies.
Yeah, it's all in contemplation of government sale. So it's
it's kind of people. If you look at how that actually works, I think people will be a little bit surprised at it. But it's legal. I mean, usually, sometimes people get in trouble for that.
We also just don't know, right? Like technically, there's no written R&D exemption.
Right.
So, but
yes, it's a bit of
all these companies develop guns, right, for potential government sale. So,
and there's no rule against using those to rent them out.
Yeah. So it's all kind of more of a gray area than people realize.
Probably. There's a lot of things like this, especially a lot of NFA stuff, as I think people have started to understand during the Biden administration. There's a lot of gray areas with these things that, given the right people in the right place, they can turn into exactly what we've seen with the Biden administration, which is these rules that try to take the gray area and turn it black, if that makes sense.
Well, and these gray areas are quite simply because the NFA was never intended to have the scope that it does today. It was only ever intended to be used as a gotcha to booze runners that were caught traveling interstate.
Yeah, the gangland era is sort of a reaction to the gangland crime, violence that happened. The Capone era, the St. Valentine's Day Massacre, that kind of stuff is what.
But they did not envision this as being used as an independent charge.
And it also wasn't. It's just not very well written.
Yeah, it's like very hilariously well.
It's like their definitions of rifle and shotgun, which have caused so much anxiety the last 100 years, are just weird.
The other little piece of NFA trivia that a lot of people don't know is why, and I know you know this, but why is it a shotgun has to be 18 inches, but a rifle has to be 16 inches?
Yes, that is a funny story.
Yeah. The answer to that is, they were both 18, but then the government sold like 30,000 M1
carbines. The largest dealer of illegal short barrel rifles in history.
Yes, the government just dumped a bunch of 16-inch guns and went, and then quickly and hastily amended the law.
The M1 carbine, for those who don't know, was a service rifle during World War II. And then after World War II was over, we didn't need such a large army and we had a lot of surplus, and they wanted to sell those to the American public, and apparently they got through selling a lot of them without anyone realizing that the barrel on a M1 carbine is 16 inches long, not 18 inches. And so they just changed the law to fix it. So that's why there's that weird discrepancy in there. But yeah, I mean, there's a lot of that kind of goofiness around the NFA, and it's frankly been one of the biggest thorns in the side of a lot of at least online gun rights activists. Like, I don't know that your average gun owner or person who has an NRA hat and gives $35 a year to the NRA cares that much about the NFA, but it's a big concern among online gun, the sort of gun tube generation where, shooting fully automatic weapons is sort of a form of entertainment. I do it. I enjoy it. I get it, but it's become a much larger priority there. And so people care intensely about this law. Not many people on Capitol Hill care about it, mm-hmm. but in the online gun rights community, it is a big thing because it limits some of the stuff that people like: suppressors, silencers, machine guns. Mm-hmm. And so to that end, let's talk about like the state of the NFA. What do you see actually coming out of this ruling? Like, we talked about a little bit that this is just a district court. It's not precedential for the entire 10th Circuit even. Where do you think it's going to go on appeal? The appeal is very likely to happen in this case, right? And do you think it's going to survive a panel in this, was the 8th Circuit, right? Which is pretty, 10th Circuit. All right. Yeah. 10th Circuit, a little less liberal, right? A little more, I don't know. What's the reputation of the 10th Circuit? Where do you see things going?
10th Circuit doesn't have a tremendous reputation here. Just like, and it doesn't have a tremendously negative reputation here. It just doesn't like have much reputation. So
they just did the pistol brace. Okay. There was the one that has SB Tactical and like 45 Republican AGs. Yeah. That was just decided. I mean, not well after the 5th Circuit. That's usually if you're looking for a pro-gun circuit, people usually go to the 5th Circuit, right?
Right.
And so the 10th Circuit is a little less at the top of the list for gun rights activists. But where do you see it coming out?
So the issue here is that there's just this public perception that no, machine guns are different, right? Mm-hmm. And that's because most people have not had enough experience with a machine gun. Well, maybe I'll phrase it this way. Most people who are in the business of arguing about and making decisions with what happens with machine guns have not had enough experience with machine guns to learn that they are not different on principle from any other self-loading firearm. If you really boil it down to principle effects, right? So you wind up having to deal with, and this was intimated by some of the concurring opinions in the Cargill decision, right? The bump stock case, where it's very clear that people who are, on our side, on the Second Amendment side broadly, find machine guns to just be like reprehensible and terrible things. Is there any legal basis to this? No, none whatsoever. But all you need is the majority of lawyers wearing dresses to agree with you. To prevent.
And I do want to get to this part later. We'll get to that in a little bit. But so it seems like you're pretty skeptical that this is going to survive a panel. We obviously don't. We can't know for sure because we don't know what the panels. We don't even know that there. I don't think there's even.
Yeah, we don't know any. We don't know anything. It's just the general opinion of non-experts, right? Who are who don't know much about guns and have just been watching this happen.
Public
is going to be. Well, obviously not that, right? Despite the fact that the obviousness is not manifest. And maybe it can be briefed out to make it clear that this obviousness is not manifest and is actually unsupported. Hopefully, that can be accomplished. But my gut is that the government will appeal this and that it won't go great. I don't think that's because it's wrong.
Right. Yeah, I get what you mean. You're skeptical that the courts are ready to accept these arguments, even if you feel like they're right.
I think that these arguments are 100,000% right. I guess I'm so jaded that, especially when the Supreme Court has intimated as it has, which, and I think they're wrong, and I think that could be fixed with good briefing, and maybe it could be fixed with good briefing here. But that's my gut feeling.
Mm-hmm. And so from that, like, if you think this particular case, one, it's not enjoining the AG from enforcing this law in the first place,
Right.
right? So it's not going to have any sort of, it's not a national injunction, nothing like that. Do you see any potential benefit for those who are looking to get either strike down the Hughes Amendment in particular or the NFA generally out of this? I mean, you're dealing with NFA cases in your day-to-day practice. What do you see as the practical effect of this?
Oh, well, immediately it lends credibility to our arguments, right? Or it's like, instead of it just being pro-gun lawyers that are making these arguments, it's, look, there's a United States District Court judge that agrees with exactly what we're saying. And so, these are going to be, this decision is going to be referred to in several of my cases and several of cases that my friends are running. So there's definitely, and that certainly lends credibility to the argument. So that's certainly positive.
Okay. That's the positive effect.
Yeah,
it's not just.
It's entirely possible.
Not just a totally irrelevant thing that happened.
Yeah, no, this isn't a nothing burger, right?
Okay.
It's starting to catch on, right? And it's the first time it's caught on. Is it likely that the first time is going to be the one that carries us all the way to the end? I mean, probabilities say unlikely, but it's certainly possible.
Okay. That's significant. And so let's real quick at the end here talk about the Supreme Court and why you're skeptical of where they might come down on this as of today. Like you said, perhaps you brief this out properly, or enough courts get on board with it, or whatever. Things could change from here. And when they take up case one, do you think it's likely they'll take up a case like this anytime soon? Because that's one issue it seems obvious at this point. They're not moving very quickly. I don't know. I'm interested in your perspective. You could argue on court time, they're taking less and less cases overall, but a higher percentage of those cases have been gun related, at least, if not directly Second Amendment related. They don't have any Second Amendment cases on their docket right now. They do have the ghost gun kit ban case. That's not a Second Amendment case.
Right.
And they just rejected a whole slew of Second Amendment related cases that even the DOJ wanted them to take up.
Right.
So it seems like, I don't know, what do you feel about the odds of a case like this ending up there?
I'm worried that, I guess I'll say, I think probably right now the right thing for them to do would be to take it and say, obviously this is unconstitutional, right? I think that maybe with the makeup of the court as it stands, it would be more likely that it not be taken, right? Mm-hmm. Because there's aspects of the NFA that are not as procedurally deficient, but definitely pass the smell test a lot less, that are being litigated right now. So I think we might see those get fully litigated first. I think barrel length and silencer regulation their days are numbered.
Do you think that this case, because one thing I wonder, one thing I see that is a potential benefit, I guess, for plaintiffs in a case like this, is that it's a total possession ban, right?
Yes.
You can't own these post 86 fully automatic weapons, outside of the small exceptions we talked about. And that's just for everyone. This is like a blanket ban on possession.
Right.
Whereas like a lot of the other NFA stuff, it's not a blanket possession ban. It's like you have to go through and register and you have to pay a tax and so forth. Do you think that gives it a leg up at all?
It certainly does. It certainly does legally. Whether that's enough to pass through the Overton window problem is a different question entirely. But legally, it absolutely does. And especially given the difference in treatment between firearms that were possessed before this date and firearms after, because you cannot explain a principal distinction there.
Because that was one thing I noticed in Rahimi, is that one of the reasons that they thought the restraining order gun ban for domestic violence restraining orders was sort of kosher, was that it's temporary. It's not a lifetime total ban. It's a temporary measure. that's specifically tailored for a certain kind of dangerous person, basically.
Well, and Rahimi also did rein in some of it, right? Because Rahimi indicated that it had to be supported by an actual finding.
Sure. Of dangerousness, right? Yeah, like Rahimi, but that's where, you know, some of these things, this starts to look a little more like DC's handgun ban. Obviously, has that Overton window issue of like the general public. Most people perceive machine guns as a lot more dangerous than handguns, even if even if it's not statistically, really handguns are used far more often in crime than any sort of fully automatic weapon is.
For sure. Now, if you're talking purely legally, procedurally, purely legally, the machine gun ban is the slam dunk. It's the slam dunk. If you look at it mathematically, it should be smacked down immediately because one, it is under all of the tests we've had under the First Amendment, where you regulate some forms of speech and not others. Right? This is regulating two of the exact same things differently. That's never held water before. Two, there's a tax structure that predicates registration, and you've just disallowed payment of the tax. That is an instant fault on the government under tax law. So they don't get the fallback of this is just a tax. You cannot treat this as a simple regulation anymore. It is a prohibitory, confiscatory regime.
And that's where it seems to have an advantage legally. But I guess to finish this off, we get into that Overton window discussion, specifically in reference to the Supreme Court, because one of the things you notice in both the court's rulings and in things like oral arguments or concurring opinions is that they seem pretty open to banning machine guns. Heller, while it was just dicta, they do, and that's a different court now, that still holds, I think, probably a lot of water in predicting where they might go. And if you look at Cargill, the bump stock ban case, where they're talking about something that is not even an actual machine gun.
Telling Congress to act now.
Right. They're basically saying that they would be, you get a number of concurrences and questions from oral arguments that make it fairly clear a lot of the conservatives on the court, who would be the people that presumably might strike down the Hughes Amendment, are pretty comfortable with Congress just going out and banning bump stocks through legislation. And they don't bring up any Second Amendment concerns to that. So I don't know.
Well, and the case was completely not litigated on Second Amendment grounds. So I guess they get to do that without, that's not precedential. That doesn't have any impact on Second Amendment litigation.
But it gives you insight into where their heads might be at.
Yeah, because at least it is tea leaf reading, right? So it's not precedential, but it is cautionary.
None of this is precedential. They have not ruled that machine guns can be banned.
They've never ruled that machine guns can be banned.
They've never ruled that. Yeah. But there are these indications that probably a majority of the court thinks that way. Because certainly the three liberal justices they all seem on board with.
They think you should be able to ban handguns.
That the Second Amendment isn't an individual right at all.
I remember Heller was a 5-4. And that was talking about straight up pistol in your house.
Right. So you already got 3 votes against it.
Yeah.
It's just a matter of whether the other 6, where they're coming down. And I think, you agree here that the signs are not great.
The tea leaves, I wouldn't be betting money on this cup of tea,
But you're still hopeful that maybe in the future that could change?
Well, it's what I'm devoting a lot of my life to, so. Yeah,
there you go.
I think we can, and I think it's going to take a lot of the stuff we've talked about. Changing discourse, getting people to understand that gun owners are not, maniacs. That what is the utility of this weapons? Why would you want to own one? And I think this is something I just thought of that I'd like to include. Ivan, my co-host on Fudbusters, he came across an old letter written in the 60s by the NSSF that was talking about how obviously the Second Amendment protects military weapons. It should only, they're by all these veterans and things, and they're saying that it has to protect every weapon that would be useful in the military. It has to protect cannons. It has to protect this and that, but not machine guns. And that's weird. And I think it might be explained that a lot of those guys were World War II vets who when they interacted with a machine gun, it was very different than how we think of a machine gun today, right? Like probably American World War II vets didn't like the MG42 very much, right? And they may have had a reasonable excuse for that. But I think that that's kind of the seed of this weird pro-gun discourse that questions machine guns specifically. But I would ask yourself, and especially on your audience, you probably have plenty of readers that fall on that side. And I'd love it if they commented. If you are a pro-gun person that questions machine guns, I'd like you to challenge yourself and ask why, and put it in the comments and let us know, because I'd love to see it.
Well, hey, I think that's a good place to leave off then.
Are you going to indicate? Where do you feel? Indicate how you feel.
Oh, well, I'm not going to take a position on the policy aspect of it all, as that's just not my role. I would, like I said earlier, I think there's legally, just as from an analysis standpoint, that it seems particularly vulnerable to this part of the NFA because of the
structure,
just finality of it. I don't know that even you read the ruling in Morgan, and the judge seems like he would be more amenable to the regular NFA regulations on machine guns, or some sort of heightened regulation,
right,
but not a total ban on possession. And so that's what makes it seem at least plausible to me that other courts could agree that this is the way the law is currently doesn't fit with the Second Amendment, as the Supreme Court has discussed it. But the main impediment to getting to those rulings is this, I think, public perception. And I think the court itself takes public perception more into account than a lot of people would like to think. Because if you look at this, to me, when I read the ruling, it was a pretty straightforward Bruen analysis. Like the Bruen analysis, I don't think has to be some super complex thing. You're really just supposed to, is this a bearable arm? If so, is there a historical tradition of regulating that dates back to the founding era? And there's some dispute over when exactly the founding era begins and ends. But, generally speaking, we have a pretty good idea of what the regulations were at the time, and they weren't that many of them.
Yeah.
And so, I don't think it's surprising to see a total possession ban struck down, just a general, everyone is banned from owning this thing. But at the same time, the public perception is that these guns are much more dangerous or scary than your average person likes. So I think that filters into the courts for sure. The court is if you look at where they've gone, we've talked about this on the show in the past, but they really follow public opinion. They're not front
way more than they should.
Heller holding that handguns are protected by the Second Amendment came way after the public opinion on handguns being legal shifted in favor of them, right? Because that was, you'd have to go back a long time to get to a point where a majority of Americans thought handguns should be illegal. And same thing for Bruen. Bruen struck down the most restrictive, almost, in practice, ban on concealed carry at a point where the whole country had already, other than a few holdouts, had already made that determination through normal course of politics by passing laws, right?
Yeah. Over the course of 2 decades, we went from very not frequently seeing people carrying guns to just kind of presuming that many, many, many people were.
And so the court is not getting ahead of those trends. They're following them much later on and sort of cleaning up the last vestiges of the old resistance to them. And so if you want to look at what's most likely in my mind for them to go after, it'd probably be something like assault weapons bans, which are similarly rare, to just like the concealed carry restriction, right? The May issue laws that they struck down were. So, and even that seems to be, I don't know if they're going to do it. right? They've been pretty resistant to going that way and taking those cases. So, and there's a lot, and Bruen has really opened up a lot of other worms, a lot of cans of worms that they probably when like the, prohibited persons lists and which of those are okay and which of those are not. That's why I wasn't surprised at all by Rahimi, because
I was
basically every state has that restriction. The domestic violence restraining order gun ban is a very popular policy across the entire country. And so I was not surprised to see them, you could talk about the way they got there.
Yeah.
And the critiques of that from Thomas and the 8-1 ruling is a weird one. You're not seeing that very often as the outcome at the court, but the overall holding, I don't think was surprising. That's how I tend to read the court. Cause I could look at Bruen and I can look at a case like this one and say that fits with Bruen, but that doesn't necessarily mean that's because you could say that of Rahimi, right? You could say there wasn't anything like a domestic violence restraining order at the founding. And that's true. And they didn't try to sort of pretend there was. They kind of mashed together a couple of. Well,
no, they literally weakened the test, and they said that they were doing it in order to get the result. And that's what you and I disagreed on. I remember we kind of we battled a little bit over the phone. We agreed that they'd get to the result they did.
Yeah.
You pretty much predicted what happened. That I was like, no, they'll give a narrow ride for this situation only because he agreed he was dangerous. But they kind of just said, no, they're going to approve this policy.
Yeah. And I think that's, just how I view what the court does in these cases. And I don't know that Rahimi is Thomas obviously looks at it as sort of the potential end of Bruen, more or less. Like you could do this for anything the way they got to Rahimi. I think they're probably what they've set up is here's what we think is too loose, or too strict of a standard, basically what the Fifth Circuit did in Rahimi. And now they have to come back. I would imagine that they will come back at some point. Probably range is what I would guess. Mm-hmm. Although they did reject taking up range. So I don't know.
Yeah.
But although range wouldn't do it. What you'd need is, and that's where the assault weapons ban cases could come in. You need a case where the lower court has gone too loose in how they're applying Bruen so that the court can come in and say, okay, Rahimi, the Fifth Circuit was too strict.
Found my other book.
Bianca, they were too loose. And so, you want you somewhere in the middle here, lower courts. That would make a lot of sense. I don't know if they're going to do that, but that would make a lot of sense.
With Supreme Court tradition, though, it's they do like bookending, right?
It just seems like, because, you can talk about philosophy and the right way to technically apply these things. And I know that that's what a lawyer would probably prefer all this stuff to be based on. But in practice, trying to go through the entire historical record to determine whether or not a law is sort of analogous or not is a pretty big ask for a regular old district court judge, even if the government is supposed to be the one who has to make that case. And so I think they're going to get somewhere where they just try to find a spot in the middle of these.
Yeah.
And that's going to be our test. And that's just that, to be fair, look at the First Amendment, First Amendment jurisprudence. How many cases, if it was simple, if there was just a very easy test that you could apply to everything and everyone would come out the same way all the time, you'd only need to do one First Amendment. We've had hundreds.
Yeah.
Right.
And we've
only had what is it now? 5? Miller, Heller,
McDonald,
Saitano, Bruen, and
Rahimi.
6.
Yeah.
6 Second Amendment cases at the Supreme Court. They're going to need more than 6 to determine it, I think.
Yeah.
But anyway, for people who want to follow your work and listen to your analysis and keep up to date with what you're doing, where can they do that?
You can follow me on YouTube, Fudbusters, for gun law related content, Fud Blasters for firearm specific content. You can follow me on the Twitter Bird app, Fudbusters. And I do have a Patreon. Subscribers to the Patreon really enable me to do the kind of public interest work that I do. So please consider checking that out. And the Patreon will give you access to one of the greatest hives of scum and villainy on the internet. So do consider it.
There you go. There's the pitch for you. All right. Well, that's all we've got for you guys this time. We will see you guys again real soon.